My intention was to get drunk and go out and hit somebody, or get drunk and drive drunk. Nobody ever intends to drive intoxicated or get to that point. I don't remember what happened, so I'm really not responsible. All right, is there anything else?
That's all we have.
All right, Mr. Daniels. All right, so everyone, just give us a moment. We're going to have medical check him out to see what's going on.
Today we've got a defendant who made one devastating mistake, one choice that ended another person's life and shattered his own in seconds. The weight of all that is written all over his face as he stands there, knowing he's staring down the barrel of 18 years in prison, and knowing deep down that he probably deserves every bit of it. The judge doesn't sugarcoat anything because courts don't deal in comfort, they deal in consequences. The reality hits him harder than the crash itself, and you can see it sink in the moment the sentence lands. This isn't one of those cases where someone tries to dodge accountability or play the victim. It's a man facing the wreckage he caused head on. And watching that realization unfold in real time is something you don't forget. Would you be able to stay on your feet if a judge handed you nearly 2 decades behind bars? Let's go ahead and dive in.
Marlon Daniels, can I have parties announced for the record?
Megan Galloway for the state.
George Sharman on behalf of the defendant.
In each cause, you're charged with intoxication manslaughter. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
And each of the cause numbers, according to the plea bargain agreement, punishment is to be assessed at 18 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. There are no applications, and the cases will run concurrently, and there's $60 restitution to DPS. Did you understand that to be your plea in each of the cause numbers?
Yes, ma'am.
Then to count one in cause number 2024 CR 009218, how do you plea?
Guilty.
To count one in cause number 2024 CR 009219, how do you plea?
Guilty.
State in each of those cause numbers, is there any evidence to support the defendant's plea?
Yes, Your Honor. The state offers states 1 and attachments in each cause.
Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty in each cause number. Are we proceeding with sentencing?
I've requested a PSI on the case.
All right, what's the purpose?
I gave it to you last week.
No, I mean, what's the purpose of the PSI?
Well,
Do you not want me to follow the plea?
no, the purpose of it is for you to see the things that he's going to be doing, and it also helps to determine his I guess incarceration, what's going to happen to him there, and it gives them a basis of information about the case and about him.
But when he is incarcerated, they will do their process to see what would be appropriate, what treatment is appropriate for him.
I understand, but they have more things that they can do here to provide that information to the prison. And it's also a mandatory right that he has to have.
I mean, if you want a PSI, of course, I will give you a PSI. I just don't understand the purpose of the PSI when you both have agreed that he's to serve time in custody.
Yes, and if you read the case law that I
No, I'm telling you, I understand that you're entitled to a PSI.
Yes.
I just don't understand the reason for it. I could see if I'm requesting a PSI because I've read the facts and maybe I'm not going to follow your plea bargain agreement, but he's agreed to prison time. I don't understand the need for a PSI. That's what I'm just trying to understand.
right, and the point is that here locally, when they do the PSI, they have more information than the prison will have on his background, his military, everything that he's doing in the community here in his education. They will have more information to take with him to the prison. They will not have the ability to do the things that they can do here.
All right. It's the court's understanding that they do have the ability to do that. However, you want a PSI, the court will give you a PSI. Ms. Abrams, see if they can expedite the PSI and I will give you a date. You're going to be taken into custody today, and let me call and see if I can get a date. All right, is there anything else?
That's all we have.
All right, thank you. Yes.
You did have
You know you messed up beyond saving when the plea deal still gives you 18 years, and without it, you're staring down a full 20 in the penitentiary like it's the default setting. And it's pretty clear the state wanted that 20 because the prosecutors don't shave off years out of generosity. They do it when the defense brings enough leverage or enough clean mitigation to make the judge raise an eyebrow. Honestly, for an intoxication manslaughter case, dropping just 2 years is basically the legal system's version of saying, fine, we'll round down barely. And you can tell his lawyer knows the stakes because he's not just standing there nodding. This man is fighting for every inch, even pushing for a PSI report done by the court instead of the prison. That's a real move. By the way, court-ordered PSI reports are usually more thorough, more contextual, and actually dive into things like military service, community work, and any background that might show the defendant isn't just the worst moment of his life. It's one of those small legal details most people never think about, but it can significantly affect things from classification to programming options once they hit the prison system. And honestly, credit where it's due, this attorney is doing everything possible short of rewriting the penal code. But even with that strong defense behind him, the consequences aren't going anywhere. Because taking someone's life on the road is one of those crimes judges don't take lightly, and rightfully so. What always baffles me is how people keep taking this exact risk in a world where Uber, Lyft, taxis, shuttles, buses, designated drivers, and literally sleeping on the curb all exist as better alternatives. The idea that someone can be blackout drunk and still think, yeah, I'm good to drive, blows my mind every single time. You're not just risking your freedom, you're risking someone else's entire future over a ride that might have cost you $20 in a little pride. And once that damage is made, there's no undoing it, no apology strong enough, no redo button, just a lifetime of consequences, and for him, 18 years of a reminder carved into his reality.
family here for victim impact statements because it is an agreement. Is there any way that he can be sentenced and then just have the PSI done?
No, once a PSI is requested, the court has to have it beforehand. If they want to give victim impact statement by Zoom, they're welcome to do that. If there's no objection, I'll see if I can call probation and get this expedited.
Okay.
009218 and 2024 009219. State versus Marlon Daniels. Can I have parties announced for the record
Megan Galloway for the state.
and for the defense?
George Sharman on behalf of the defendant in these cases.
All right, and you're Mr. Daniels?
Yes, ma'am.
All right. Mr. Daniels, the court, at the request of your attorney, had a PSI ordered. And Mr. Daniels, we're going to proceed with sentencing. And each of the cause numbers, you entered a plea of guilty. And the punishment is to be assessed at 18 years in the prison. Mr. Daniels, I've had a chance to learn more about your background from your attorney, your military service. And I will tell you, I know that no one, at least I have yet to have someone come before me and say my intention was to get drunk and go out and hit somebody, or get drunk and drive drunk. Nobody ever intends to drive intoxicated or get to that point, but it happens. And that's why I always try to stress to everybody, please, please, if you're going to be drinking at all, even if you think it's just going to be one drink, it's better just to have a designated driver, right? Okay. And I do appreciate the fact that you entered a plea, that you accepted responsibility by pleading guilty, and that you have not wavered and try to blame something else for this. I do note that you said that you couldn't remember, but you know it's true, and I appreciate that. Sometimes people will say, well, I don't remember what happened, so I'm really not responsible. But you didn't do that. And the fact that you entered a plea, and in each of these cause numbers, you were looking at 20 years. And I always tell people, when people go to jury trial, even when I was a defense attorney or as a prosecutor, I sometimes would have to explain to families, you don't know what 12 people are going to do, right? When you go to jury trial, you don't know. 12 people could say, you know what? This person before me is a military veteran. This person before me hasn't been in trouble. Yes, they did this, but we're not going to give them 18 years. Who knows, a jury may decide to have given you 2 years or 3 or 4 or whatever. You just never know. So for you to accept responsibility, for you to take the 18 years, knowing that by taking these 18 years, there is no appeal because you waived your right to appeal. I think that says a lot, even though I know that the family is in a lot of pain, because when you lose someone and you lose someone this way, it's not expected. The court is recognizing that you entered pleas of guilty to each cause number, that you accepted responsibility, and you took close to the maximum sentence in each of the cause numbers. With that being said, and cause number 2024 CR 009218, the court will follow your plea bargain agreement as previously stated. When you entered your plea, the court is finding you guilty. The court will sentence you to 18 years in the prison. There's a $2,000 fine. The court will give you credit for any time served, and legally, you're entitled to any time that you have served on this case. This will run concurrent with 2024 CR 009219. I'll request the therapeutic community. The therapeutic community doesn't increase the time that you're in custody. It's merely designed to help you maintain your sobriety, address any type of mental health or substance abuse issues you may have, so that ultimately when you're released from prison, you will maintain your sobriety. And there's an affirmative finding of a deadly weapon.
May I address the court on the matter?
Just one moment.
Yes.
And cause number 2024 CR 009219, the court is finding you guilty. The court will sentence you to 18 years in the prison, give you credit for any time served. There's an affirmative finding of a deadly weapon. This will run concurrent with 2024 CR 009218. There is to be restitution of $60 to DPS for testing, and the court will recommend the therapeutic community. There's something you wish to say, counsel?
Yes, on the PSI, it said that he had the combat risen. He did not have the combat ribbon. So that was erroneous.
Okay.
Step number 2, it shows there were 2 priors of misdemeanors. There was only 1. And if you look at it, it's the same date on each.
All right. Is there anything else?
That's all we have.
All right, Mr. Daniels. Deputy Laura, if you'll give him his trial court certification, counsel.
Yes.
All right, your client has been removed from the courtroom. Did you review the trial court certification of defendant's rights to appeal with him?
I did.
All right. On the record, the court informed the defendant that by entering the plea, he had waived his right to appeal, so he acknowledged that. I followed the plea bargain agreement. So because I followed his plea bargain agreement and because he's waived his right to appeal, he do not have the court's permission to appeal.
I went over that with him, Judge, so he understands.
All right. Thank you. All right. So everyone, just give us a moment. We're going to have medical check him out to see what's going on. And then if you will be patient, we'll have him brought back out if they say that he can be brought back out. And then you can give your victim impact.
At the very least, this defendant is doing something a lot of others in this courtroom universe refuse to do, taking responsibility instead of pretending the laws of physics and accountability don't apply to them. There's no fake tears, no blaming the weather, no my cousin borrowed my body stories, just a man realizing the full weight of what he did. In the moment that 18-year sentence dropped, you could see it hit him like a physical force because he collapses almost instantly and has to be escorted out. His head down, eyes closed, swaying back and forth. Those aren't theatrics, that's someone feeling the ground shift under them. It's hard to tell whether it was a genuine medical issue or if reality finally connected to the part of his brain that had been running on denial. And since this is a plea bargain, there's no backup plan, no appeals, no second shot, no let's try this again with a different judge. This is it for him. And honestly, cases like this should be broadcast way more often because this is what real-world consequences look like, Not the sanitized version people imagine when they think they're good enough to drive. One stupid, reckless choice can spiral into a lifetime of loss that you can't drink your way out of, apologize your way out of, or charm your way out of. And it really makes you wonder how many lives would look completely different if people took 10 seconds to think before getting behind the wheel. Thank you so much for watching. Don't forget to like and subscribe, and I'll catch you in the next one.